Hi everyone. This is the group for week 9, which goes over privacy and civil equality. I'm Hannah.
I'm Brianna.
I'm Sierra.
I'm Aiden.
And I'm Emma.
So I'm going to start. One of the first reading was a harassment case study, and it talked about Jamie. So Jamie was born in Ashland, Wisconsin. From the time he was a young kid, he was facing harassment from his fellow students because he was a gay individual. He would report the abuse to school officials, but nothing would ever really come of it. The counselors were sympathetic, but they could only do so much. The fact that he told them angered the harassers even further, and he was subject to more abuse from them. As he got older, the abuse he got worse, and to make matters worse, the principal would do nothing to help Jamie. He basically said that it was Jamie's fault that these kids were harassing him because he was gay. The harassment got so bad, his parents convinced the Department of Social Welfare to put him in a foster home in a neighboring school district so he'd go to a different school. He did so well while he was at this different school, but they decided to pull him out and put him back at his home. The harassment began immediately whenever he returned home. So to further explain this, the discipline was never actually put out to the abusers that were abusing Jamie. But records show from the school that students got suspended for calling other students bitch, and other students got in trouble for smoking on school property. The turning point for Jamie was when he got beaten up so badly in the school library that he suffered from internal bleeding and bruising. He decided to leave Ashland School District, or Ashland in general, I'm sorry, for good this time, and left for Minneapolis. While there, Jamie was able to find solace while there, and he got his GED. He went to college and majored in psychology. He then went around to schools presenting to students, teachers, and admin about protecting LGBT students. And he also talked about how everybody should take anti-gay harassment seriously. He was so committed to this that that this is why he wanted to school the Ashland School District. So my first questions are, I think that Jamie was fortunate to have parents that were supportive of him when he was younger, even if it did take his father some time to come to terms with Jamie's sexuality. But what do we think his life would have looked like if his parents had not advocated for him? And then another question that I posed is, why do we think social services took Jamie out of his foster home and the new school when he was doing so well? So then to go on, I'm going to talk about the lawyer who helped Jamie. So like I said, Jamie decided to sue the Ashland School District. He called the Lambda. It's a gay rights activist group. And because he wanted to file a lawsuit against the Ashland School District and some of the admin who did not intervene when he was being harassed in school. At first, Lambda did not take on LGBT youth cases, but in the mid-90s, he decided that it was time. As we can imagine, what was happening to Jamie was happening to many other LGBT students in the country. A study found that 45% of gays and 20% of lesbians had experienced physical or verbal abuse. Another study found that 41% of girls and 34% of boys who had reported this violence attempted to commit suicide. Lambda knew that they had to take on a stand in these cases now because of these shocking reports. The lead attorney was Patricia Logue, and she was in charge of the Midwest branch of Lambda. While she was in law school, she fell in love with a woman, realizing that she had been a lesbian all of her life. Logue had a history of working for nonprofits who represented poor and minority populations. And in her first case with Lambda, she was able to persuade Chicago's Bid Billiken Parade, which is the largest African-American parade in the country, to reverse their original decision prohibiting a Black LGBT group from marching under its own banner. When Logue first heard about Jamie's case, she said that this case would serve as a test case that could potentially help protect LGBT students across the country from being harassed in schools.
Well, a little bit more into the court proceedings. So the statute that Logue and Jamie decided to sue under was Section 1983, which is called the Ku Klux Klan Act, which was enacted after the Civil War against government officials to hold them accountable for not protecting African Americans from violence and discrimination. But due to like the broad wording, pretty much talking about the equal legal protections that everyone is like subject to, that's why they sued under that, because it was such a broad wording. So, and their principal argument stated government officials were being, well, punished for discriminatory reasons, had failed to provide him with the protection from violence and harassment to which he was entitled to under state law. In Wisconsin, there's equal protection law, just like in most other states. Logue, that's how you say it, right? Recruited David Springer, an experienced trial lawyer, for Jamie's trial because she was unexperienced in trial, just in trials in general, and she knew she needed like a backbone, and he had won many other cases dealing with LGBTQ youths. So he, so they went back to Wisconsin and actually got one of the tormentors, Jamie's tormentors, Roy Grande, who was actually serving time in prison for assault, I believe, as well as Roy Grande's mother, to testify for him. And they ended up going into the trial, and they did testify for Jamie. Roy talked a little bit about how when he had called his girlfriend the B word, he got suspended. But when the principal had found out about how he tormented and harassed Jamie, there was no disciplinary action taken. And due to all that, sorry, it's okay.
I'm so sorry.
No, you're fine. The jurors unanimously all voted that the defendants intentionally discriminated against Jamie, which would have led them to going on to like the damages part of the trial. But Logue warned Jamie that that the defendant's lawyer will come after like your personal life, and they will try to just find every little secret, and they will try to like make you look bad because of like your social background. So they decided to settle the case, and they settled it for $900,000 and $62,000. But Logue also knew that settling cases could also come with forcing schools to, I'm trying to think, enact LGBT protection, youth programs, and creating reasonable punishment for these harassers and tormentors.
Mm-hmm.
Okay, I'm sorry. So then the questions that we have for after that are about the case rather. If Lambda would have taken cases that had to do with LGBTQ youth in its formative years, especially when Jamie was in middle school, do we think that Jamie would have had a different time in school? Another one, sorry about that, is during this class, we have talked a lot about how representation matters. Do we think that since Logue was lesbian, that this meant more for Jamie to have somebody from the LGBT community to represent? Now after that.
So then we're going to move now into the harassment, the sexual harassment case.
Oh wait, no. Is it the sexual harassment? Or is this the sexual intercourse one?
Sexual intercourse.
Okay. Go ahead, sorry.
No, you're good. Can everyone hear me?
Yeah.
Cool. So in this reading, we were first introduced to the story of John Lawrence and then Tyrone Garner, I think that's how you pronounce it. And basically these two were being arrested for having violated the Texas homosexual conduct law. So basically what that is in 1973, Texas turned their sodomy statutes to only specifically target people of the LGBTQ community. And we'll get into that later. But basically what happened was John Lawrence, who was a Caucasian Navy vet, was moving into his new home, and he had a friend named, his last name was Eubanks, and he was an ex-boyfriend of Tyrone Gardner, who is a younger African-American male, who, and I think it's important to mention that Lawrence was closeted, but Gardner was a little bit more out and people knew. So basically what happened was they were all together at Lawrence's place, and Eubanks wanted to leave with Gardner, and he didn't like that. He didn't want to. Gardner didn't want to go. So Eubanks, in a fit of jealousy, makes a false police report saying that there's an African American with a gun at this apartment complex, trying to harm people. And so they come into Lawrence's apartment, and they find Gardner and Lawrence having sexual intercourse. And I think what also is important is that there's two different stories from the two officers that were there. So the one says that they were told to stop, but they didn't. And that's why it was like it came under um the it came under the amount of punishment that it did. And another one said that they stopped immediately as this began. So this is the beginning of the trial that will come later, but on my section of the reading, I think it's really important to take time to talk about what the sodomy statutes were. So basically what it is was sodomy statutes in the United States could be traced back to the English Reformation Parliament of 1513. And basically what those were is it wasn't exactly against anyone of the LGBTQ community. It was specifically against anything against nature. So this prohibited men from having anal intercourse not only with other men, but with women, children, and animals. So into the 19th and 20th century, this also went into including oral sex. And then by the mid 20th century, sodomy was a I can't say it. Anyway, it was,
synonym.
yeah, thank you. For homosexual acts. So basically what happened is as time went on, it was these laws and rules were basically made to specifically target the LGBTQ community. And as we said before, Texas became the second state to actually make it so they flat out said it was against homosexuals, which is really just not great. So my questions were, why do you believe sodomy statutes changed from what their original purpose was to being focused on more on the LGBTQ community? And why do you believe that these laws existed even though their charges were rarely filed?
Thanks, Hannah. Sorry.
Oh, you're good.
So, going more in depth with the sexual intercourse study that we looked at, Hannah touched on a lot of points that I wanted to talk about too, but I kind of found a lot of comparisons in the two cases and how there was a real invasion of privacy to these couples. And I think that's like the key point of why they're so valuable in this movement. So I kind of took out key points of what happened in each case. And so the first case in 1986, which was, I'm blanking, Lawrence versus Texas is what Hannah was explaining, but Bowers versus Hardwick was, I think, a similar situation where a man was given a false ticket for something on a different date, and he was charged with it, and the officer tried to find him in his house and found him having sexual intercourse with another man, so and so. So basically this case in 1986, they took to court but didn't really receive justice for what they were wishing. a key point made in that was how the court's response was essentially saying just because it was in your home doesn't mean it's not unconstitutional and illegal. So I think the views of the courts at the time have definitely changed going into viewing Lawrence versus Texas in 2003, which was the case that Hannah was explaining with the jealous man upset that he couldn't be with these other men. So he filed a police report, or called the police, I'm sorry. And so once this was taken to court, I think a lot of views changed at the time in between this almost 20 years. Is my math right on that? Yeah. Okay. How the views changed in the courts. So it was overruled, and then I did a little bit more research past this, but it also said like the Texas sodomy law was expelled in other states too. So a few questions that I wanted to pose were regarding these cases. What ways does violating sodomy laws represent the LGBT community? And I mean like the people bringing this attention, this almost negative attention to this community of what these people are doing. That's really upsetting. Like this isn't really good publicity, I would say. So like how is it representing the community in that time? And how have the views of the public or the court shift from this huge time period when these laws were repealed? Thanks.
Okay, so when I get nervous, I talk really fast. So I'm probably going to talk really fast when I do this. But I did the workplace case study. So it was basically talking about workplace discrimination laws in different states throughout the country. So one of the most important notes that they put was the Equal Protection Clause of the 14th Amendment, which stated that no state shall deny persons the equal protection of the laws. And that specifically applied to public employees, but not private sector employees. Private sector employees could essentially get fired for pretty much anything unless it was like violate their contract that they were under. Some part of this is the fear of people coming out in the workforce. There's a survey done in 2013 that 1/3 of participating LGBT Americans state that all or most of their coworkers knew their sexual orientation, and then 50% stated that no one knew their orientation at work. And so that was mainly from different views that people had stated that they were fearful of being harassed or fired or discriminated against. And so one question that I had wondered was, why do you believe that private sector employees are not covered under the Equal Protection Clause like public employees are? So something else that they had really highlighted was the Fortune 500 companies, which are the largest companies in the United States based on their total revenue. It highlighted why they would support gay rights and why they would basically highlight their LGBT employees. The first idea that they stated was that these companies are competing for the best employees, which they would set standards for their competitors to follow. So basically, if they were to get like the best employees, other companies would want to be like them and get best employees. The second that they had stated was there was a growing understanding that closeted gay employees are not as productive or effective in the workplace, because they would be fearful of if they were to come out about their sexuality, they would be discriminated against or fired. So they knew that if they were having so much pressure being in the closet while at work, it would affect their job and how they were performing their job. And then the third thing that they had highlighted was that large corporations harbor controversy in a good or bad way. They really highlighted that the companies profited from supporting LGBT community, and they had highlighted that in, what was it? It was 2010 where Target donated to a group that was opposing gay marriage. And so a lot of people were starting to boycott Target. And so like Chick-fil-A, how their CEO donates to a lot of anti-gay companies and organizations. And so a lot of people also boycott Chick-fil-A and other organizations like that. Companies supporting the arts like film and theater and like music, they unfortunately cannot control all the information that goes out to the public, even though it's supposedly private, but it kind of gets out there anyways. But it's not really seen as an issue whether or not they come out as gay or any other part of the LGBT community. For like major league sports like football, baseball, coming out is usually seen as like the end of their career. There was a case where there was an athlete in 2013. He was a soccer star, and he came out. His team had already known, and they were supportive of him. But once he publicly came out, there was a lot of backlash that people were saying he should be kicked off the team. So 2 questions that I had posed for this was, what factors do you believe contribute to the differing views of LGBT people in the world of art and sports? And then another one I had thought of was, do you believe that since large corporations profit from the LGBT community, that these corporations should be required to donate to pro-LGBT charities and organizations? And then the last thing that I had talked about that they really highlighted in this piece was domestic partnerships. So domestic partnership is an interpersonal relationship between 2 individuals who live together and share a common domestic life but are not married. Before it was legalized in the United States for same-sex marriage, a lot of gay couples would apply for domestic partnerships since they could not legally get married. So now that they're able to legally get married, they can still file for domestic partnerships, but it's not found as useful as actually being married and filing like as a married couple. So gay couples and sometimes heterosexual partners, depending on like their situations, are offered the opportunity to register as domestic partners without offering special benefits. So public and private employers are required to treat domestic partners the same way as a heterosexual marriage in states providing same-sex marriage, which it is legal throughout the United States. But there are some states that have laws that kind of still discriminate against it. There's a study done in 2013 on the Corporate Equality Index that 62% of the Fortune 500 companies do offer domestic partnership health benefits. That still leaves a big chunk of them that don't, though. And between 2000 and 2008, there were 19 states, Pennsylvania, thankfully, is not one of them, enacted amendments that had very broad language, and it made it easy to bar same-sex marriage and also civil unions and domestic partnerships, making it significantly harder for people of the LGBT community to have access to these things.
Okay, and that's that's all we have for you today.
Bye.
Bye.